Good morning, everyone, and welcome to our Hull and Hull Breakfast Seminar. I'm Susanna Popovic-Montag, and I'm very pleased to be here with you today. And I welcome everyone who's joining us, not necessarily in person, by web, and the individuals who are calling in as well. Very nice of you to have come in, notwithstanding the rainy, yucky day that it is out there, but it seems to be par for the course for our breakfast, doesn't it? We do have, I hope, a very interesting seminar for you today on estates and family law issues. And our guest of honor, our main speaker, is unfortunately running a little bit behind, but Fareen Jamal will be joining us shortly. In the meantime, I just wanted to take this opportunity to introduce those of us from Hull and Hull who are here so that you can put a name to a face. We've got, of course, Ian Hull, who's going to be presenting today with Fareen, as well as Paul Trudell, David Smith, Natalia Angelini, Suman Jaffrey, Moira Vishu, Holly LaValliant, Stuart Clark, Jonathan Cappy, Noah Weisberg. We're also pleased to have our students here, our summer student Olivia Mann Foster, and our newest articling student Reese Newman. We've also got our clerks here. We've got Heather McGuinness, who's our Passing of Accounts Estates clerk, Heather Fritchkowski, and Christine Mercer. A very special thank you as well to Sarah Koslicki, who you have met, I'm sure all of you, and Diane LeBau. So with that very long-winded introduction, I will turn it over to Ian to start our presentation.
Well, as you can see, we've got microphones on the floor as always, but we do welcome any interaction in this discussion today. When Fareen gets here, she's going to deal with some of the specific case law that we wanted to highlight, but if she gets tied up, we can work through it ourselves. But the first thing we thought we'd want to sort of break down, we wanted to sort of address family law and estate law issues, which is a natural crossover in many respects, both in terms of our practice, but certainly in terms of the courts. While we, as litigators, experience different approaches by the judges in the family law bench when we're in front of them, on the rare occasion we are, at the end of the day, the law is very importantly intertwined, and we wanted to see if we could highlight some of those recent developments and talk a little bit about some of the tensions that exist between them. So, the starting point in any, oh, here's great, Fareen's here. Come on up and grab a seat, and we'll put you on the hot seat very quickly. I'll let Susanna, why don't you just take a moment and introduce Fareen.
Fareen Jamal, this is everyone. As we gave a brief introduction in your absence, but we're very glad that you could join us.
Sorry, I'm late.
At the Bales Beal firm, and we're very lucky to have her come and join us and add and supplement to our discussion. So what we just thought we'd start with, as I said, we're going to try to highlight some of the recent developments of the cases to illustrate some of the important crossover points. So the first case we'll start with, and while Fareen settling, Susanna and I can work through this first case, and that is a recent decision of the court in fair comment that we were involved in this case at our office. So we've had some involvement with the we involved at the trial level, and so far it's just a recent decision. We're not sure what's happening next, but it's the estate's called Jasinski Estate, and Susanna, maybe you could talk a little bit about it in terms of the facts, which are fairly straightforward. It's a dependence relief case, and it helps us really focus our attention on how the courts are going to and continue to address claims made by common law spouses in the Jasinski case, a relatively long-term relationship. So unmarried spouse claim, and the Jasinski case is a starting point to help us see how that's working along.
Thanks, Ian. I always like when there's ethnic names and cases that I get to talk about, so I'm very excited about this decision because it really is, as Ian says, an excellent illustration of what the courts are doing with support claims, particularly in light of the fact that we're seeing more and more of these relationships of a common law nature. The relationship here between Danny, and Bonnie was one that lasted 12 years, and Danny basically called himself a house husband. He was met Bonnie worked with her at her company. She had a car lot, and he was employed by her. And Bonnie had one daughter, and that was basically all of her family, of course, grandchildren as well. And in 2009, Bonnie created some wills. She had a prior will where she, at some point in time, made a provision for Danny and left him $1 million in her will. She subsequently did a very complicated estate plan in 2009, shortly after she was diagnosed with cancer, and essentially cut Danny out of the will, both wills. What we had here ultimately, in terms of big picture, Bonnie died with an estate worth about net $16 million, and Danny had a lot less, as you can imagine. And so when they did the relative comparisons, following her death, the executor of her estate was her daughter, who was a co-executor with another individual, and the two of them decided that in the circumstances they would give a gift, gratuitous gift to Danny of $1 million, sort of recognizing that there was a prior will, that he was involved in her life, and as I say, gratuitous transfer of $1 million. So when the court was looking at this, and it was Madam Justice Greer who dealt with the decision, she had a situation where she was faced with an individual who had about $1 million in a relationship with a woman who had $16 million. And so it was one of those wonderful instances where we really see a judge consider moral claims, and that was really what happened here. And of course there was the traditional nature of the need as well that was assessed as part of the ongoing responsibilities that the estate had to Danny as a long-term common law spouse. So I think what I thought was the most amazing part of the decision was really just having a really deep, knowledgeable analysis of the whole nature of support law in Ontario. And what Madam Justice Greer did is she started, luckily, the parties actually agreed, and there was an agreed finding that Danny was a dependent of Bonnie's estate. And so that didn't have to be very hotly contested, but what did was whether or not he was entitled to support, and how much more than what he had already received. The position of the estate trustees was that he got nothing. He had enough. He may have been a dependent, but he was sufficiently provided for. And Danny, of course, did not agree, and neither did, fortunately, Madam Justice Greer, or unfortunately for the estate, as the case may be. In terms of the final result, what had happened is that Madam Justice Greer made a finding that he was entitled to about $4 million of her estate. So an estate worth $16 million, a quarter of it went to Danny on the basis of her legal analysis of his need and entitlement to support. The Cummings decision, of course, was first and foremost in the court's mind, and as was the Pickett's decision, Pickett's versus Hall Estate, which was a 2009 British Columbia Court of Appeal decision. And in that case, the court dealt with a similar situation where there was a very large estate. And the court held that there was, in that circumstance, a very strong moral obligation to provide for someone if the estate permits it. And Madam Justice Greer took that kind of reasoning, applied it to the facts before her, and made a very similar finding.
And so the whole helpful part of this decision at this point, subject to any appeals and so on, is there have been really literally 2 cases in Canada in the last 5 years that have dealt with dependence relief with larger estates. The case that Susanna referred to in British Columbia is the other one, and it's about an $18 million estate, and the dependent got about a third, a little bit more than a third. So this case, the dependent got $4 million of $16 million. So you can get a little bit of a sense now that the judges are starting to have to address. I mean, so many of these cases settle, so it's very hard to find any precedent law on it. So that in and of itself is worthwhile. I just think that was helpful, and thank you, Susanna, in terms of giving us a sense of where these bigger estates are going with the dependence relief. It's very hard to judge these cases when you have a smaller estate, because sometimes the need encapsulates the whole estate. I mean, if it's a $500,000 estate and you've got a relatively young person, as it was in the Jasinski case, there's a good likelihood there that the court would almost give most of the estate, if not all of it, to the dependent if they had a good claim. So the levels of percentages can be adjusted according to the size of the estate. And the last point was, which was interesting, was the estate in the Jasinski case really focused on the intention of the deceased. And as it's a factor in Section 62 of the Act, intention of the deceased is a factor of 1 of 26. But the estate sort of felt that that was a prevailing element of what the court should consider. And as it turns out, certainly anyway, Justice Greer used some of the other factors to impose the decision on them. So, Farine, why don't we now talk a little bit about some of the case law developments that your expertise has flown between, and you do both estate and family law. So,
yeah, I deal with the dead and depressed.
Very nice. So I won't impose the order on you, but does it make sense to start with Kerrigan, or
sure,
is
Kerrigan's
that okay?
good, yeah.
All right. So the Kerrigan decision, which is an important decision to consider in the context of estates and family law tensions. So go ahead.
So the Ontario Court of Appeal gave us Kerrigan in October 2012, and it was purely a legal issue. It's who's entitled to receive a pension death benefit of a member of a pension plan, and this was a deferred pension plan. It wasn't in pay. If he's survived by both a common law spouse and a legally married spouse from whom he was separated but not divorced, and whom he had designated as the beneficiary of his pension plan. So Melody and Ronald Kerrigan married in 1973. They separated in 2000. In 2002, so 2 years after separation, he designates Melody and their 2 children as the beneficiaries of his pension plan. But in 2000, right after he separated, he starts living with Jennifer Quinn. So the issue becomes, when he dies, spouse in the house is Jennifer Quinn, but designated beneficiary and from whom he is separated but not divorced is wife, Melody, as well as the 2 children. What's interesting about this case is that wife, Melody, continued to live in the matrimonial home that was jointly owned by the husband and the wife. And then you have the condominium in which husband lives with new common law spouse, but that is also owned by husband and wife. So everything is jointly owned between husband and separated wife at the time of his death, which you would think would solve a lot of the problems, because she would get a whack load from the condominium, being the survivor, and from the home, but she doesn't because of the debts that he had racked up that neither Mrs. Kerrigan or Mrs. Quinn knew at the time that he died. So although she's the sole beneficiary of everything, she's the sole beneficiary of the residue of his estate, she gets the survivor of the condominiums, they fight about the pension, about the survivor benefit of the pension. So what I found a little bit interesting was that in 2006, Mr. Kerrigan discusses with Mrs. Kerrigan and his daughters, I think I should leave something for Miss Quinn. Like, I've been with her now for 6 years, I think I should leave something for her. So how about we change the condominium ownership, or I leave something for her. And although he consults with a family lawyer in 2006, he never follows through. He never signs the separation agreement or court order or anything else. So this case, the trial decision was heard by Madam Justice Nolan, and she like most of us would, I think, agree, says spouse in the house wins. Spouse in the house gets the pension benefits. But it's heard at the Court of Appeal. Justice Jurians gives us the decision. It's a 2-1 decision. Justice Epstein concurred with Justice Jurians, and Justice Laforme gave us what I think is a very persuasive dissent. But in reaching their decision, they do a very comprehensive statutory analysis of Section 48 of the Pension Benefits Act. And the Pension Benefits Act, the interesting part is Section 48 sub 3, and it provides that subsections 1 and 2, which is where the spouse in the house would rule, the words are do not apply. So do not apply where the member or former member and his or her spouse are living separate and apart on the date of death. So it's the words do not apply. So Justice Jurian says, well, Mr. Kerrigan is living separate and apart from Mrs. Kerrigan, so the spouse in the house rule does not apply. That means it does not apply to anybody. So we throw that out, and we are simply looking at who were the designated beneficiaries. And the designated beneficiary is Mrs. Kerrigan and the 2 children. So the Court of Appeal said, if you've got 2 spouses, a separated spouse and a common law spouse, and you fail to divorce your separated spouse, and you're living separate and apart from them, then automatically that will cancel out, and the spouse in the house priority rule will not apply. We will only look at the designated beneficiary at that point. So there was a lot of uproar in both the family bar and the pension bar because we had all assumed that spouse in the house rules, and many pension benefits were paid out on that basis. There was also an uproar from the common law cohabitation spouses, because the issue is they're becoming second-class citizens because you can't live separate and apart from a common law spouse. So in in the definition, you've got issues as it stands. The bigger concerns were the policy considerations, right? The goals of protecting spousal interests are eroded, and instead we're favoring choice, right? Who are you choosing as your beneficiary? They asked for leave to appeal, which was denied to the Supreme Court of Canada. But I know from sitting on the OBA Family Law section that there is a lot of work on reforming that section of the Pension Benefits Act. The issues are, the Federal Pension Benefits Standards Act is very clear. It provides for this issue. So if it's a federal pension, spouse in the house still rules. They actually use the term survivor instead of spouse, which would trump any designated beneficiary, which meant that in Ontario we have two conflicting pension schemes, if you're in a federal scheme or in a provincial scheme, but the provinces are looking to update that. The other issue was the wording in the Pension Benefit Act for both deferred pensions and also pension and pay is exactly the same. So this would also apply to pensions and pay because the wording of spouse and the do not apply is exactly the same. So it causes a bit of an issue. When I think about it, I think, well, what if he had named his brother as beneficiary? I mean, if we're talking about choice, it's not about who she was in terms of the fact that she was the former spouse. It was that she was the designated beneficiary. So I could designate Mickey Mouse. And Mickey Mouse will get the pension if I have the two spouses that conflict each other out. What's the takeaway for us as lawyers is to remind our clients to update their wills and testamentary dispositions, especially following a separation or divorce, and reinforce the importance of finalizing a separation through a valid agreement or a court order. So if they want to benefit the common law spouse, they should get a divorce right away. Designate the common law spouse as the beneficiary of the plan in a proper beneficiary designation. Alternatively, if you want to actually benefit the married spouse, which perhaps he did because it was 2 years after separation, then designate the married spouse and ask the common law spouse to sign a spousal waiver. Get a domestic contract with the common law spouse so that there's none of these uncertainties when you actually die.
Well, that's excellent, and thank you very much, Farine. We especially at our seminars, try to be very practical about it, so those are great checklist points to address with our clients now, with the Kerrigan decision being the law and subject to only statutory change at this point. So thank you very much. Just to continue to work along that theme of practical talking and considerations here. We're going to talk a little bit about the Spencer and Riesberry decision and then do some more analysis on the Kerr, Supreme Court of Canada decision on Kerr, and see where that's come and gone. We've spoken briefly about that at this podium in the past, and we want to talk a little bit more about that with Farine here today as our special guest. Let's just interject, Susanna, quickly with a couple of the questions that we have. We try to make this interactive, and we have this new fancy system which collapsed on us today, and so it's not going to be able to go up on the screen where you're able to anonymously vote on these things. But I just thought we'd do the first couple questions to the audience, and maybe we could just do a show of hands, and there's no wrong answers. When you deal with litigation, we will always come up with an alternative argument. So here's...
Okay, so an election under Section 6 sub 1 of the Family Law Act is irrevocable. Is that true, false, or not sure? How many people think that the election is irrevocable? Nobody? How many think that it is revocable?
Nobody.
And not
we asked
sure?
this question. Perfect. Susanna, we look to you for the answer.
Actually, I thought you were going to give us the answer. The answer is that it is, in fact, it could be irrevocable. And so the answer would be true. And there's a reason for that, and we have some authority for that, and that is actually a decision, the Iasenza decision, which is a relatively recent decision where a court went through the analysis and determined that in the particular circumstances facing it, it would be possible to use its inherent jurisdiction to allow a spouse who had incorrectly elected for an equalization to withdraw that and take under the will, essentially. So it settled what seemed to be at that time, very much uncertainty. And it was an interesting case where the judge sort of did the right thing for the woman in the circumstances.
So Farine, let's talk a little bit about, we can, the three of us can talk about it if we need to, but Spencer and Riesbury, and then we'll maybe briefly talk about the Hansen decision before we go into the Kerr stuff. So Spencer and Riesbury, why don't we talk about it and its impact on our joint bars?
So Spencer and Riesbury is a 2012 Court of Appeal decision. The issue is that a family home can escape the matrimonial home designation if it's held through the structure of a trust. So it's not actually the first time it's been held. In Clark and Reed Estate in 2000, Justice Panet made a similar decision, but given that this is a Court of Appeal decision, it got a lot more interest from both bars. So Linda Spencer has 4 children. One of which is Sandra Spencer. In 1993, she buys a property. We call it the Riverside Drive property. And she immediately executes a trust agreement and settles the Spencer Family Realty Trust. So the trust property is the Riverside Drive property. She has 4 children. 1 year later, in 1994, the eldest, Sandra, gets married to Derek. And the case that we have is a matrimonial case between Derek and Sandra after they separate in 2010. And Derek says, well, we lived in this house the entire time. I think there was 2 years that they didn't live in the house during the marriage when they were doing renovations or major structural changes to the property. But for the majority of the marriage, they lived in the house, in that house. He says, this is, as far as I know, a matrimonial home. They're just trying to escape the trust argument. He makes 3 arguments. He says, firstly, it should be included as a matrimonial home because Sandra is a beneficiary of the trust, which is sufficient to establish an interest in the property. Or secondly, Sandra, in 2005, I think, in 2005, Linda adds both Sandra and her sister, the 2 elder sisters, as trustees to the trust. So he says, well, the second argument is she's a trustee of the trust combined with a beneficiary of the trust, so that together is sufficient to establish an interest in Riverside Drive as a matrimonial home. Or thirdly, that enforcing the notion of the separate entities of trustee and beneficiary is defeating the special treatment afforded to matrimonial homes in the Family Law Act. So the Court of Appeal looks at this and they say that the trial judge was correct, that it is not a matrimonial home, that as a beneficiary, Sandra has a contingent beneficial interest in the trust property as a whole, but not in Riverside Drive in particular. What is helpful, or some of the other facts that I glossed over quite quickly, was in about 2005, Linda buys 3 more properties for the other 3 children and adds them to the trust as well. So all 4 children are living in trust properties. They're treated equally. The other issue is that Justice Campbell, who is what happened is they bifurcated the trial. They had a trial of an issue of whether or not this is part of a matrimonial home. And Justice Campbell hears the trial of that issue and says, it is not a matrimonial home. She doesn't have an interest that's sufficient for it to be a matrimonial home. But she's a contingent beneficiary. That has some value, and that value must be included in her net family property, that she can't exclude that despite the provisions of the trust. Now, what got appealed was only the issue of whether or not it's a matrimonial home. So unfortunately, we don't have enough information, or we don't have a court that's decided on the issue of whether or not the exclusion provisions that we put in our trust agreements are going to be upheld. But solely on the issue of whether or not this is a matrimonial home, the Court of Appeal says Sandra did not have an interest that was sufficient, and that you can't combine being a trustee and a beneficiary to try to combine and conflate an interest. One doesn't exist. As a trustee, she's a fiduciary. And she has obligations that flow from that. But as a beneficiary, she's a contingent beneficiary because the trust provides a life interest for Linda, who is still alive. And she's only a beneficiary if she's one of the surviving beneficiaries when Linda dies. And we don't know what property is going to exist when Linda dies. Like, it's such a, what-if scenario that we can't, at this time, say, no, you have an interest, and it's an interest that you can call upon. The Court of Appeal was very clear in saying a beneficiary doesn't have an ownership interest in any particular in any particular asset, and that there was no provision in the trust agreement that Sandra could call, or any of her siblings had the right to call on the transfer of any specific property, both while Linda was alive or even after Linda was dead. What's interesting is that the Family Law Act, Section 18 sub 2, provides a special distinction for matrimonial homes that are held through corporations. So you can pierce the corporate veil. The case of Deborah and Deborah in 2006 did just that. They said, you're a shareholder, you have an interest in the corporation. This is just a ruse to try to take the matrimonial home out of the special treatment that it's afforded under the Family Law Act, and we're not doing that. That's still an interest that's sufficient for it to be considered a matrimonial home. So the question is, how is a trust and those mechanisms different from a corporation and those protection mechanisms? The Court of Appeal says the distinction lies in the fact that the Family Law Act is very clear. It deals with specifically a corporation, and we can pierce it. It does not for a trust. So the commentary that arises after that case came about is whether there should be, whether trusts should be delineated the same way that a corporation is in the Family Law Act, so that we pierce that, so that we do include it as a matrimonial home. Really, what the Court of Appeal has given us with Spencer and Riesbury is a way to have a one-sided marriage contract, right? You can exempt it from the matrimonial home protections, but you do it without having the dialogue that comes with a marriage contract, the give and take, the disclosure. Perhaps the spouse doesn't even know it's being held in a trust. So that's where it becomes problematic. Some of the family law bar was in uproar about the fact that we're circumventing the special provisions. I personally think that all the special provisions in a matrimonial home should be abolished, so I have less issues with that. But the special provisions created by a matrimonial home create several unfairnesses, right? You can't deduct a home that you bring into the marriage. If you have exclusions or gifts from third parties that flow into the matrimonial home, you can't claim those. So there's unfairnesses that exist. All we're doing is creating a new set of unfairness, and I think that can be problematic. Finally, we don't know if future governments or courts are going to plug the gap. So this is an area of uncertainty. I think the advice I'd give to our clients is that a fairly negotiated marriage contract is still advisable, because you don't know what the future is going to do. And as tempting as it would be to use this one-sided marriage contract, there is an unfairness that is inbuilt that lots of people speak out against. So I would just be wary. I'd use caution in advising that.
Well, thank you very much. This one-sided marriage contract idea is really, it's actually, this case has found some international attention. I was at a conference recently with a group of international lawyers, and the Court of Appeal decision was embraced as a sort of an important restatement of the necessity to preserve trust law. And so, I mean, it will be interesting. I think the courts will ultimately probably find a way to get around it. Maybe there'll be a statutory change, but I think it'll be hard to change the statute because the concept is that if you're going to create a trust, it's got to mean something, and that's what Justice Gillese said in the Court of Appeal. Talked about the difference between fiduciaries and beneficiaries, the fundamental elements of a trust that are very different than a corporation. And from that standpoint anyway, it's a helpful decision for us to wave around as trust lawyers. The family law bar has their own issues, which is always the case. But the other comment I noticed at this conference was even universally, everybody describes the family law courts in their own jurisdictions as courts that will do just about anything until they get to an equity court, and then the equity court has to follow some rules. So it was interesting that the similar feeling comes from the tension between the family law and the state's bar here, when we find family law judges will ignore just about everything they can or do whatever they have to do, which is probably all for greater good, but sometimes frustrating in the context of trust law. All right, we've got some time now. Let's spend some time on the Hansen decision, if that's okay, because this is a case, again, of the Court of Appeal. It's near and dear to my heart. Jordan Ayton was, when he and I first met, probably 15 years ago, he had just published a Estates, Trusts, and Pensions Journal article on the whole question of joint tenancy and the severance of joint tenancy by conduct. An important element of any family law case, because the conduct and the case law that addressed it, the conduct between the two spouses can, in and of itself, through their lawyers, sever the joint tenancy. And Jordan, that many years ago, wrote an article on it, and now the Henson decision, as in large part restated, but it is a helpful refresher on conduct and severance of joint tenancy and those sorts of issues. So, Farine, maybe we could turn to you and we'll have a little dialogue on the Hansen decision.
Absolutely, but I love the anecdote about Jordan Aiden and Ian Hall, right? They both deal with at the edge of the cliff, but Jordan creates the fences and Ian deals with the dead bodies at the bottom of the cliff.
Happy to do it, too. I'm an undertaker.
So Hansen Estate and Hansen. So we all know it's trite law. There's 3 ways to sever a joint tenancy. The first is by unilaterally acting on your share, such as selling or encumbering it. The second is mutual agreement between the co-owners to sever the joint tenancy. And the third is through any course of dealing sufficient to intimate that the interests were to be mutually treated as constituting a tenancy in common. That's a mouthful. So this case is about the course of dealing. So Barbara and Willie Hansen, they were married. They separated. They're negotiating a settlement of the outstanding issues between them. They're well along in their separation discussions. They've both made offers to settle. Both offers suggest that the home gets sold and they each have a 1/2 interest in the property, that it gets equally divided. But he dies before they finalize anything. So the largest asset is the matrimonial home. It's being held as joint tenants. But they had done several things. Barbara had moved out of the matrimonial home. She's obtained an appraisal of the home for the purposes of dividing it. She's opened a separate bank account. He's changed the expenses, the billing name of the expenses on the matrimonial home to him alone. He's changed the locks on the home, and he's executed a new will that excludes Barbara as beneficiary. But they haven't completed a formal severing of the joint tenancy. So the issue is whether or not they have severed it by conduct. The Court of Appeal says they have, and that what they had done, all of those actions that they had taken, would suggest that by conduct they have severed their joint tenancy. In the family law bar, we think that they've really lowered the threshold for what would be considered a finding of severance of joint tenancy through a course of dealing. Equity should intervene to stop parties who are going to assert a right of survivorship. If it would be, because of their conduct, it would be unfair. But really, we're looking at, or would confer a windfall. And that's what the Court of Appeal said. It said we would be giving a windfall to Barbara if we let this happen. But was there enough conduct to suggest that they had severed a joint tenancy? The reality is that it's fairly easy to sever a joint tenancy. All you have to do is register the deed against title for your own half. The bigger question is, when he did his will, why didn't he do it then? So my advice to council is follow LawPro's advice. LawPro tells us to canvass the issue of the severance of the joint tenancy at your earliest opportunity. In the materials, I've put our standard letter that we have along with our retainer whenever we have separated parties, and it reminds them of 3 things. Change your will, change your beneficiary designations, and think about severing your joint tenancy, and we can help you with all of these, and this is what we need to do. So right at the get-go, we tell them off the bat that, these are the things you have to consider. But the advice that I would still give is use the deed. I find it troublesome that this was considered a severing of joint tenancy, and I don't think we could rely on it or advise our clients that this is going to be sufficient.
Thank you so much. That reminds me that we have the benefit of Farine here today, but also the benefit of her substantial efforts in the paper with very helpful precedents that she's just referred to at the back. So thank you again for that, Farine. All right. So,
and if I could just interject, from an estate planning perspective, I think one more thing that we might suggest to add to these 3 things to consider in a separated kind of situation when you're faced with someone who's just coming to the end of a relationship is to also consider creating a new power of attorney right away. Yeah. Because in most cases, you're naming the spouse who's no longer friendly, and you'll want to make sure that you've covered that off as much as you possibly can.
No, that's a very good point. Add that to the checklist. I know some family law lawyers actually insist that their client not leave the first meeting if they're serious about it, and they do a holograph will right on the spot to make sure that they've covered off the evil husband taking all the money on because he's standing outside ready to run her over or something. All right, let's go back to our practical questions. Behind door number 2, Susanna, we've got, let's go to the next question on the spousal question on the election, okay?
Can a spouse who's named in a will, who elects to take an equalization, act as an executor? How many people think that they can? And how many people think they cannot? And the actual answer is they cannot. Again, we have the courts to thank for that very definitive answer. And the Reed versus Martin decision dealt with that exact situation where a wife named in a will chose to elect to equalize the net family properties. And as a result of that, the judge held that she was not allowed to continue on and administer the estate.
It's divisional court, so it's got some meat to it. All right, let's spend some time now on the ever-present and new concept that is really restating the old as far as I'm concerned, but we have to respect the fact that the Supreme Court of Canada now calls it a new name, joint family venture. Who in the room has heard of the concept of the joint family venture? All right, we're gonna spend some time talking a little bit about the Kerr decision, which was the one that developed this concept. You may find there was some overlap to existing law. My personal view is I think it's just restating the old, but there are some really unique elements to it and some recent developments with regard to Kerr since it's come out that we can consider, because the joint family venture idea is something that we toy with now in the estates bar. Should we be adding that on our list of when we want to put together a claim for dependence relief, proprietary estoppel, resulting trust, constructive trust? Should we put joint family venture on that list? And is it a distinguishable element of a proper claim that we should consider? So, Farine, why don't we spend some time on Kerr, and then maybe a little bit of time permitting on some of the developments with Kerr.
Okay. So, Supreme Court of Canada, I think it was January, but it was 2011, Justice Cromwell gives us the decision it's actually two cases. It's Kerr and Barano and Vanessa and Sega. And the Supreme Court of Canada gave us one set of reasons on both of those decisions, and they explore the elements of an unjust enrichment claim. That's really what it came down to, and how to value these claims as they exist for unmarried spouses. Before I even get into it, there's been a lot of discussion about legislative reform for unmarried spouses and including them in our provincial schemes, the equalization schemes. In Manitoba, in Saskatchewan, in Nova Scotia, and now in British Columbia, unmarried spouses are brought into the fold. In Ontario, however, we believe that unmarried spouses have the freedom to choose an alternative family form, and they have the freedom to choose not to have rights or obligations imposed on them, or so we think. And then you have the joint family venture that was created by the Supreme Court of Canada and Vanessa and Sega and Kerr and Barano. So the first one of the things that they did take away was the common intention resulting trust, which I was very pleased with, because I never fully understood the concept, because I don't know how you'd have a common intention. The only intention that matters is the intention of the grantor. There is no such thing as a common intention resulting trust for family law anymore. It's not used at all. In fact, since Kerr and Barano, it hasn't been raised at all. The resulting trust hasn't even been raised as a claim in the case law that has happened since Kerr and Barano to December 2012. I'm sorry I haven't updated the case law. We're only at December 2012 in terms of how much we've done since then. So the Supreme Court of Canada says there's two types of unjust enrichment claims. The first is where the couple have a joint family venture and one partner retains a disproportionate share of the wealth and assets generated by the joint family venture. The other type of unjust enrichment claim is where you do not have a joint family venture, but one partner provided uncompensated services and or contributes to a specific property held by the other. Unjust enrichment is a restitutionary remedy, so it does not create a presumption of equalization. And the mere fact that parties are cohabiting doesn't establish an entitlement of one party to share in the other party's property. So unjust enrichment, the old three-part test, there's got to be enrichment, there's got to be deprivation, and no juristic reason. So what we've added to that is a nexus or causal connection. There has to be a causal connection demonstrated between the contributions and the acquisition, or the preservation, maintenance, or improvement of the property. So the joint family venture is a way to claim a monetary compensation where there's an unjust enrichment, but there's no property or direct contribution. what is it? Like, how do you determine whether a couple is in a joint family venture? This was really uncertain, because you look at the two cases, Vanessa and Segan and Kerr and Barano, couples who have been together, I think it was 25 years for one of them, and they were not a joint family venture. So I would think after 25 years, how much more intertwined could you get? But what the court looks at, it's a 4-part test: mutual effort, economic integration, actual intent, and priority of the family. It's evidence heavy, so you've got to have a lot of evidentiary basis to try to prove these 4 pieces of the test. They look at, courts look at the pooling of effort and teamwork, the decision to have and raise children together, the length of the relationship, whether there's a conjugal relationship and whether it's an exclusive conjugal relationship, the use of the parties' funds and whether they're entirely for the family's purposes, whether one spouse does the majority of the domestic labor to free up the other spouse to work in the workforce, the conduct of the parties, and whether they're holding out themselves to the world as an economic or domestic unit, and whether they intend to give priority to family. I look at this test and it looks to me like a compensatory spousal support claim. Like, it's the same kinds of elements that in family law we would make for a compensatory spousal support arguments. The degree of financial dependence or interdependence of the parties, and the ownership, use, and acquisition of property. So the cases since Kerr, there have been 38 cases from January 2011 to December 2012. Out of those 38 reported cases, 28 cases found a joint family venture. And what the cases are turning on is length of relationship and really whether or not there's children. Credibility of the partners and the quality of the evidence really lends a flavor to the case. I mean, you read the decisions and it really boils down to what was the evidence, was it good enough? So of those 28 family law, joint family venture cases, the average cohabitation was 14.6 years. In the 10 cases where there wasn't a joint family venture, the average length of cohabitation was 7.8 years. In the materials, you have the list of both cases, all 38 cases, and which ones, how many children they had, and how long their relationships were. In those cases, in the 38 cases, 16 cases had children. 13 of them were considered joint family ventures. The 3 that were not are all anomalies. First of all, they're all husband cases, which again in spousal support also has its issues. In one of them, in Baker and Harvey, the court says that the couple never even cohabited, so complete anomaly. In the second one, joint family venture wasn't pleaded, but was only raised in obiter by the court. So all 3, as far as I'm concerned, are anomalies. If there's children, there looks like there's a joint family venture from the cases that have happened since Kerr and Barano. The only other thing I wanted to comment on was exclusions. So there hasn't been any guidance actually on exclusions. So for married spouses, we would have exclusions for gifts from third parties or inheritance. There has been no comment or review of either of these issues for joint family venture cases. But they are taking into consideration what parties brought into the marriage. So like we have in the equalization scheme, you know, the snapshot of what you bring into the marriage and the snapshot of what you leave with. Here they are looking at what you came into the marriage with and giving you credit for that in the joint family venture cases since Kerr and Barano. It's still an uncertain area in terms of how you value it. Some cases gave 50%, some cases gave 30%. It was all over the map in terms of evaluation exercise, which is the same whether you look at dependence relief or compensatory spousal support. There isn't really any guidelines except for what we have in the spousal support advisory guidelines, but nothing like that exists for joint family venture yet. The only other 2 cases I wanted to comment on were about married spouses, but I can do that in a bit if you like.
No, let's finish the thought.
Okay, so 2 cases, actually they're 2013, Straub and Straub, 2013 case. Justice McKelvey is looking at whether or not constructive trust is available for married spouses. And we all know since Rawlock that it is. I think it's a problem. I think personally that it's a mistake. PEI, who have their Family Law Act based on our Family Law Act, removed that exclusion. They said you can't claim a constructive trust if you're a married spouse. You have the equalization scheme. That's what's available to you. But in Ontario, since Rawlock and Rawlock, you can claim a constructive trust if you're married spouses. Justice McKelvey in Straub says, very much like I like, no, I don't think so. You have a statutory framework for equalization. You can't use constructive trust, and it shouldn't be routinely applied in married cases. And he says, you know, there's unequal equalization. There's other remedies available. You don't have to resort to constructive trust. So in his case, in Straub and Straub, he said neither of them meets the test for constructive trust. But then you have the case of Horch and Horch. It's actually a Manitoba Queen's Bench decision. But in that case, you do have, much like Rawlock, the fact that you can claim constructive trust, and you can claim a joint family venture for married spouses. Same problems. There's no accurate yardstick to measure the value of the claim, but you absolutely can claim it, and that case was used as a means to claim a joint family venture for married spouses, and they gave them 50%.
Well, those are excellent illustrations, and I think it's similar in the estates bar. What's grown over the past 10 or 15 years in the estates field is new claims, in a sense, new ways to attack the existing estate plan with proprietary estoppel or expanding into concepts of joint family venture. And it's interesting to see how the court is struggling in the family law side with constructive trust claims, because we use those if and when needed. We'll use, we'll manufacture as many angles as we can to help equalize and regularize it for our clients, or to defend it and fight it for, depending on the circumstances. That's fascinating.
It's concerning. When you have multiple remedies for multiple situations, it leads to more litigation, more uncertainty, lengthier trials. I mean, that's why we try in family law to have guidelines and equalization schemes. It's to try to remove that from our sphere, particularly because of how acrimonious those cases are to start off with. But it's creeping back in.
Yeah, well, I think every time you struggle to codify something, people want to push back, and the pendulum goes back both ways. So we, on the estates side, are happy to continue to see different angles, because we don't want any codification of anything that will just slow us down. No. All right, so I just take a pause here for a moment here. We've sort of covered a lot of ground in the crossover, and we've got a few minutes left. If there's some questions that people want to launch at this point, we want to welcome that opportunity, just because we're in a free-for-all here in some ways. So there's a couple microphones here if you want them. All right, so then we have a bit of time here to I wanted to take a few minutes, Farine and Susanna, just talking a little bit about some of the fundamentals behind the application for equalization on the death of the separated spouse. And maybe not 101 level look at this, but just explore sort of the regime that exists, so that we can be reminded of what steps will be taken as a solicitor doing estate planning work. What does this whole equalization process mean? Starting with Part 1 of the Family Law Act, which establishes the regime of equalization of net family property. So in simple terms, in very simple terms, and Farine will jump in and tell me how off this is, but I describe the equalization process in three parts. One is each spouse calculates his or her own net family property, NFP. They subtract the net value of his or her property on the date of marriage from the net value of his or her property on the valuation date. And it's similar in a dependence relief case in its own way. I mean, at a trial, you're supposed to calculate how much is at stake, but the truth is a court wants to know sort of what people went into the marriage with, what they went out with, and what's the net numbers. So that's the number one step. The number two step is the difference between the NFP, then of course is divided in half, and then three, the spouse with the greater NFP pays the amount calculated in respect to the second step to the other spouse. So that's really how the calculation process works. Maybe a little, as I say, simplified, but that's a good starting point. Section 5 of the Act sets out three possible conditions that give rise to equalization. So we've got separation, divorce, and annulment under Section 5 sub 1, and under, obviously, for our world, death, Section 5 sub 2 is our favorite. That's a fairly important trigger. And then number 3 is improvident depletion of assets, Section 5 sub 3. So those are the sort of 1 and 3 really deal with, Farine, your world when you're in the family law scenario. Do you see a lot of the improvident depletion of assets as the trigger cases? It seems to me that must be, I don't know, it must be a sort of a unique set of facts you have to have.
Gambling? So the cases that tend to have improvident depletion cases are where there's been gambling. and what's the other one? Gambling and sometimes alcohol abuse. It really depends how far bad it is, but those tend to be related anyways, the gambling and the alcohol abuse cases. And so you have the improvident depletion for really those cases.
Because it's interesting, you see in our sphere sometimes guardianship applications get created by a spouse who has sort of fallen over the edge with lifestyle choices and has gambling and drug addiction and so on, and has really genuine cognitive weaknesses as a consequence of maybe the drug use or whatever. And the Section 5 sub 3 element of it is always one that you sort of toy with in terms of whether you've got the nice, the spouse who's not suffering sitting across from you saying, look, she's got access to all the money, she doesn't come home, she's got drug use problems, I want to bring a guardianship application to prevent her from moving and any of these assets around in the family. And often that we've looked at this improvident depletion issue as something that we say, well, maybe you should go down the hall and go see a family law lawyer and trigger it in that regard. So that's interesting. Okay, separation, termination of marriage, section sub 5. The death of a non-separated spouse is dealt with in sub 5.2. That's a little different because when a spouse dies, if the net family property of the deceased spouse exceeds the net family property of the surviving spouse, the surviving spouse is entitled to 1/2 the difference. Well, it's only a one-way on death. It only goes one way on the calculation. So that's just something to keep in mind in terms of how the Act works. And there are quirks in every respects of the Act. The limitation periods under Section 7 sub 3 set out the formal limitation period. With respect to applications based on sections while you're alive, section 5 sub 1 or 5 sub 2 when you're dead, deals with the 2 years after the date of marriage is terminated, or 6 years after the day the spouses are separated, or 6 months, of course, after the spouse's death when we have a death in a classic estate scenario. Do you find, Farine, in your practice, the limitation period under 7 sub 3 an issue that you're dealing with from time to time, especially this whole idea of 6 years from the date the spouses separate?
So, like you talk about family courts doing what they need to try to make it work, I think in the limitation period perspective in particular, we recently had the case of Huxtable, which was 10 years. Limitation period, and they said, well, it's a constructive trust claim, and those actually have a longer limitation period from the Real Property Limitations Act. So we're still going to have it go. So it's how long is a piece of string?
Well, it's interesting too, and it makes sense in some ways that the court's got to look at that. We see it sometimes when we're having to get into cases where we're trying to act or defend the validity of a marriage, because that's declaratory relief under the Act. And so under the Limitations Act, there is a strong argument that there is no limitation period running for the time when you want to bring an application for a declaration of the marriage is invalid as a result of lack of capacity and those sorts of things.
That's
so
interesting.
Yeah, so we're pushing the envelope anywhere we can. But it's important, obviously, that the core limitation periods. I always say to students who are about to do the bar ads test, there's only 2 questions you know for sure are going to be on the exam every time, and that is when is limitation period for dependence relief, and when is the limitation period for Family Law Act. We keep that in mind, and the interesting twist that we're always struggling with is with the subsequent changes to the primary and secondary will. Susanna, and you've run into this as well too, with the limitation period in dependence relief cases there. Do you want to talk about that just briefly?
Yeah, I mean, that's a really interesting issue in the sense that it's nice to have these fixed limitations, and we know that in order to bring a claim for dependence relief, you've got a 6-month window from the date that you get probate. And when you're dealing with a multiple will situation and you're only getting probate of the primary will, it leaves open the question as to whether or not the secondary will, which is not probated in that secondary estate, is subject to a claim for support outside of the 6-month limitation period.
Okay, so Farine, if we could just put you on the spot the last couple of minutes here. In your precedent materials, you deal with the insurance designations, and I just thought maybe you could walk through those just briefly with the audience. And I think they're found at right at the end of the printed version that you got. Your version is your own, but Fareen's done some great work on the insurance designation issue, and maybe she could just highlight what she's got there so that people know what gems they have in their package as they leave to go back to the office.
So life insurance is used to secure child or spousal support in our separation agreements. And what I've given you is several precedent clauses. One of the issues that we see from the estate side is poorly drafted life insurance clauses and separation agreements. And so what I've included in the materials is better drafted. The bigger concern is, or one of the issues we see is, it's held in trust it's held by Susanna in trust for my children. And that's a bare trust. That you're not securing child support with that, because all you've created is a bare trust. All Susanna can do is hold that money until the children turn 18 and give it to them. And I think there's just, when it comes to the disconnect between family lawyers and estate lawyers, this is the biggest area where estate lawyers can really help family lawyers understand what to do better. Set out what the trustees' obligations are. Set out what they're supposed to do. When are they going to make payments? How are they going to make payments? How are they going to wind it up? Are the amounts going to be paid out of income or capital? Are the amounts going to be invested? Set out very clearly, like you would do for your trust agreements, exactly what is happening. Unfortunately, too many separation agreements are just far too bare and don't deal with these issues, so then we're litigating after they die. The other one was, there was the case of Turner and DiDonato, and that was the issue. It was a $100,000 life insurance claim. There was no change. There was no adjustments that were to be made as the child support, or spousal, it was spousal support in that case, decreases over time. So when he died, the wife's actual outstanding claim was about $43,000. So the estate paid her, I think it was $43,500. I have the exact number in my material somewhere. But she said, no, the separation agreement provides that I'm supposed to get a face value of $100,000. It doesn't matter that my entitlement has decreased. And the court agreed with her. Right? There was no adjustment clause in that separation agreement. There was no adjustments that were made. So you can have 1 month of spousal support left and still pay the full amount. Unfortunately, we don't, when we're drafting the separation agreements, I don't think we spend enough time thinking about these consequences. Often, when recipient spouses are the trustee for the life insurance, they don't realize things like, don't commingle the money, you're a trustee. Keep it in a don't intermingle the funds, hold them in a separate fund, keep them invested, report the income in a trust tax return. These are the types of issues we see from the intersection that I just want to, they're perhaps worth reminding your clients. Make sure that a third party is named so it doesn't flow through the deceased estate, so that you don't have to pay the estate administration tax, or it's not subject to creditors' claims. If you write it out well enough, it's a testamentary trust. So you get the graduated tax rates, at least for now, so long as they don't change anything. If it's an inter vivos trust, you're taxed at the highest marginal tax rate. If you're creative enough, you can create two testamentary trusts, one for the child support and one for the spousal support. So you've got two sets of graduated tax rates. So there can be ways to be very creative in the drafting. I've given you the precedent clauses. Finally, one of the things that we always wonder is, in fact, there is now, well, there's about almost two. There is, what is the best insurance product available for securing child and spousal support? There is one called Family Sure, which deals with the decreasing obligation over time. And there is one that's coming out in the market now called Rebalancing Beneficiaries. And what they do is, as one decreases, they allow the remaining amount to increase, and you can designate a separate beneficiary for the increasing amount. I mean, there's creative ways to try to deal with this. All I'm asking is turn your mind to it. Make sure the family lawyers you know are not doing the simple bare trusts. There's too many problems from the estate side.
Well, that's fantastic, Fareen. Those arrangements always remind me of the classic banks that want to come and sell you life insurance on your mortgage, and when your mortgage is almost paid down, and they only have to pay out the amount that's owed on the mortgage. So you've been paying on a $100,000 policy, but they're only paying out $6,000 on the mortgage when you die. So It's a little secret the banks want to keep for themselves, I think. But, all right, so let's thank you again, Farine. And as I say, she's at Bales Beal. She's a fantastic family law lawyer that's been demonstrated time and time again, but she's got this great dovetailing of her practice with both family law and estates. So we really appreciate you taking the time and coming to the Hull and Hull breakfast and
Thank you for
giving
having me.
us your words of wisdom. Our next breakfast is October 17th. Back at the same place, and you'll get notices and topics and all of that being advised. So it's 9:30. The bell is ringing. Back to school. So thanks again for your attention.